So, namaskar.
Okay. What are you doing at present?
Right now, I'm preparing for judiciary.
Why are you interested for joining judiciary as a judicial officer?
Sir, at the very first place, it is a very noble profession, and by pursuing a career in judiciary, I will be not only able to uphold the individual liberty and individual right of citizens. Apart from that, I will also be able to hold the constitutionalism of the constitution, and apart from that, also it is there is a social job security and social and economic stability also.
What is arrest?
Sir, arrest means a temporary deprivation of personal liberty uh, by the police officers.
When a private person can arrest a person, another person.
Yes, sir, a private person can arrest a person provided that the offense is a cognizable one.
When a police officer can arrest a person in a non-cognizable offense.
Yes, sir, as per section 42, a police officer can arrest a person in respect of a non-cognizable offense if he intentionally does not provide his true identity if it is asked by the police officer.
What is confession?
Sir, confession is given under Section 24 of Indian Evidence Act, which suggests that a true admission of the guilt by the accused himself.
It has been defined in Evidence Act, confession.
No, sir, it is not defined, but the Supreme Court in various cases has interpreted the term. At the very first place, it was interpreted in the case of Paklanarayan Swamy. The term confession has been defined.
A person confessed under the influence of liquor before his friend that he committed murder. Is it admissible in evidence?
So such type of confessions are treated as a extrajudicial confession. It is a very weak piece of confession unless and until it is corroborated, sufficiently corroborated in the court of law. It has no probative value.
Okay. Who is an expert?
Generally opinion is not relevant under Indian Evidence Act, but opinions of an expert is relevant. It is defined under Section 45 of Indian Evidence Act, where a person having a special skill in a particular subject of law, science, or any foreign law, uh, such persons can be treated as an expert.
What is hearsay evidence?
Uh, Evidence, the statement of a person, maker of the statement, if he has not seen the thing directly, or if he has not perceived the facts through his own eye, ear, or uh, hearing also, it can be treated as a hearsay evidence.
Is there any exception that hearsay evidence is admissible?
Yes, section 6 is an exception to that, where if a fact, though not in issue or not relevant, but forming the part of the same transaction, it can be made relevant.
What is dying declaration?
Dying declaration is given under section 32, subsection 1, to suggest if any statement is relating to the cause of his death or any circumstances under which the death is caused, such statements can be treated as a dying declaration.
What is the difference of dying declaration in as per Indian law and the law of the UK?
There is a very thin line of difference. The main difference is that the anticipation of death. If the maker was under the anticipation that death is a probable consequence of the of his present situation, then such statement is relevant under the English law. But there is no such requirement of anticipation in Indian law.
When admission of a third person is relevant,
Uh, Sir, I'm not sure, but if I am allowed, I may guess that, sir.
don't say. Can an admission be made by this by a person be used against in his favor? If a person
Yes,
has
sir.
made admission somewhere, can he use that admission in his favor?
Yes, sir. Favorable admission can only be made as per Section 21 of Indian Evidence Act if it is relevant under Section 32 of Indian Evidence Act between any third person, then it will be a relevant one. If the admission is made at or about the happening of a particular event, then also it is admissible, sir.
What is primary document evidence?
So primary evidence, if the evidence is produced itself for the inspection of the court, it is treated as a primary evidence.
What is secondary evidence?
Sir, in case in the absence of a primary evidence, a secondary evidence is allowed. That is, if something the carbon copy or the oral accounts of the person who has seen himself or any counterparts, all of the things are secondary evidences, sir.
Can you give the best example of secondary evidence? Which is the best example of secondary evidence?
So, and as far I can only remember of the carbon copies or certified copies.
Is there any prohibition for giving secondary evidence?
Yes, sir, if the primary evidence is available, then in that case, no secondary evidence can be given.
What is writ?
Sir, in case of if it is given under Article 32 of Indian Constitution, if the fundamental right of a citizen is violated, he can directly approach to the High Court or Supreme Court to restore his fundamental rights, sir.
The High Court is required to restore the fundamental right.
Uh, Sir, as per Article 226, writ can be maintainable.
What is the difference between the writ provision as per Article 226 and Article 30?
Sir, Article 32 is itself a fundamental right, whereas Article 226 is not. Article 226 is having wider interpretation, where a normal constitutional right, if it is violated, or any legal right is also violated, Article 226 is maintainable. But Article 32 is only for fundamental rights.
What is basic structure theory?
So the basic structure theory has emerged in the case of Kesavananda Bharati case. As per this, the Parliament cannot amend the fundamental rights or the basic nature of the Constitution.
Suppose a person was arrested without following the provisions as laid down in section 41 of the criminal procedure, and he approached the Honorable High Court that his fundamental right was violated. Is it maintainable?
Yes, sir. In case of arrest, his right of personal liberty is at stake, so he can uh, highly read before the Honorable Court.
What is anticipatory bail?
So it is given under section 438 of CRPC, where a person, if he comprehend that uh, he may be arrested in a given case, then he can approach to the Honorable Court of Session or High Court to for an anticipatory bail.
Is there any criteria for granting anticipatory bail?
Yes, in recent amendment of 2018 amendment, there is uh, strictly impediment that a strict impediment is that if the accused is uh, concerned with offense related to 376 or any other sexual related offenses of children below 16 years of age, then in that case, anticipatory bail will not be granted to him.
Who is a competent witness?
As per Section 118 of Indian Evidence Act, the competency of a witness has been given. Every person is a competent witness unless uh, he is not able to depose a fact due to the old age or infirmity. Then in that case, he is not a competent witness.
Whether an innocent person is a competent witness?
Yes, sir, he can be a competent witness if he can uh, understand the nature of the question, sir.
What is substituted service of summons?
Sir, it is given under Order 5, Rule 20, that if the summon cannot be served in the ordinary course of nature, or if the defendant is apprehending the summons, then the summon can be served can be served by attaching a copy at the conspicuous place of his house or at the courtroom, or it can be circulated in the regular daily newspaper in the locality, sir.
When temporary injunction is to be issued?
Sir, if the defendant threatened the person to damage the property, or if there is any risk that the property can be removed from the jurisdiction of the court, then in that case, a temporary injunction can be issued.
When there will be attachment before judgment?
So, Order 38 talks about the attachment before judgment, that if there is a threat that the property can be damaged, or the property can be disposed of before the judgment, if there is any such kind of threat, then in that case also the property can be attached.
When receiver will be appointed?
So to protect the subject matter of the property, as per the Order 40, the receiver can be appointed
When
until the
commission will be
judgment is
issued?
not pronounced. So
When
as per Section
commission will be issued?
75. Yes, sir. As per Section 75 of Code of Civil Procedure, a commission can be issued for any other ministerial work, for the examination of the witnesses, for partitions or inquiry for mean profit. For all these purposes, a commission can be issued.
When a declaratory suit will lie?
So, if the legal character of any person is disputed, then there can be a suit for declaration under Section 34 of Statutory Relief Act, who is contesting or disputing the legal character of that person.
When mandatory injunction lie?
Uh, Sir, if there is a breach of obligation and a specific act is to be performed, then the court can grant mandatory injunction after going into the merits of the case.
Okay. Yes, I will give you some feedback. Let you understand. Then, what is arrest? Arrest, I put a question. I put a question, why you are interested for judicial service? Your simple answer, because it is a prestigious, secure, and independent service. This much. Because the judicial service is a secure, prestigious, and independent service. Then my question was, what is arrest? Arrest means taking a person into custody by the police or by the court. Not more answer, more sentence must be told, because by when you give lengthy answers, you create problem for yourself. That this much. So if arrest means a person taking a person into custody, either by police or by the court. Your answer was also for a temporary period. For temporary period or till the completion, or till the completion, temporary period or till investigation is over or till a case is completed. In a criminal case, only a criminal case. Arrest is made in a criminal case by taking a person into custody of the police or by the of the court. Private person, if a private person can arrest, if in his presence a person commits a cognizable and non-bailable offense. Non-bailable offense. This is maybe very but police officer, non-criminal offense police officer can arrest if the person doesn't furnish his name and address in a non-criminal offense to the police. Then he can be. Confession has not been defined again and again. I told you, confession is admission of committing guilty. A confession is admission of committing a crime. That is confession. It has not been defined. Confession is admission of guilty of committing an offense. That will be confession. Under drunk, because confession under even a person is drunk, if it is not given to the police or held in police custody or to a person in authority, then that is admissible and confession in evidence. I did not put to a question what is the evidence circle. You should not exceed. That is admissible. How much the interviewer wants. Then expert. Expert means when a person is skilled on a particular subject, he is called expert. Person who has a special means a skill on a particular matter or subject, he is called expert. That will find expert to definition. That is expert. Hearsay evidence means hearsay evidence is that evidence which is deposed on hearing something from the other. A person who has no direct knowledge about a particular fact and he deposes in court, he says something in court, hearing from others, that is hearsay evidence, that is not admissible. That is exception to hearsay is a resident, even dying declaration. This is also exception to hearsay evidence. These are yes. Dying declaration means any statement given by a person regarding the cause of his death or any of the transaction, any of the circumstances of the transaction resulting his death. That is admissible evidence when the cause of that death is in question in any proceeding. Then that is dying. The difference is that in immediate apprehension of death, imminent death in English law. But here, whether he was expecting death or not, that is there in section 31. Regarding whether he was expecting death or not, it is important in India. But in English law, that is, he must be in immediate, that is, apprehending, this apprehension of immediate death. That is admitted. Then, time declaration. Admission of third person is relevant. It is when a position, when the admission of a third person whose position is to prove as a party to the suit. The best example. X used Y for not collecting rent from Z. So in this case, the Z liability is to prove. If Z had given a statement that he was liable to pay some money to X, that is admission. So admission of a third party when whose position is to prove as against a party to the suit, that is relevant, though it is a third party. That is. Or third party admission, favorable, that is favorable admission is not there. Favorably, this will be proper. Admission any statement is whose position is to be proved, or a party has referred to an opinion of a third party. That is that example you should say, you should see. Primary evidence is that that document itself. The original document is called primary evidence. Secondary evidence means when original document is primary evidence is not available, then secondary evidence is best evidence is certified. This best example of secondary evidence is certified. Certified copy. Well, you may get a question: what is certified copy? Certified copy means any copy given by a public officer certifying that a particular document with his signature or seal, that is the true copy. That is certified copy. Best example: the secondary evidence certified. There is a prohibition for secondary evidence, that is, except certified copy or other there should be a notice to produce the original. If it is not there, the original is lost, original has been destroyed, that you should see. In such case, secondary evidence is admitted. Because then what is writ? Writ is a command of the High Court of the Supreme Court. That is it. Article 32 and Article 32 is a fundamental right or enforcing fundamental right, but Article 226 is not a fundamental right. There the High Court has for any other purpose. It can be given wider power than the Supreme Court. Then, yes, when Section 31 was not followed, the person can file a writ. Even High Court can, because there a person's life liberty cannot be curtailed without procedure established by law. So, without procedure established by law, Section 41 is a procedure prescribed by law. If that is not followed, it can be filed. Then declaratory suit, when a person is denying somebody's legal title or legal character, legal status, then he can file a suit to declare that he is entitled for this. That is declared. So, if mandatory injunction to enforce against an obligation, if it is possible, that is, you should see it, that proper definition. Receiver is often just and convenient. These two words. When court finds just and convenient, it can appoint receiver. Not protection. Just convenient word is there. In this context, a Madras case is there, you search for it, a Panchashila, high principles of settle, that is receiver.
So Krishna
That is,
Ramaswamy Chetty, sir.
that is receiver case. You should be aware. Then commissioner will be that is examine a witness, to make local investigation, to do any ministerial work, to effect petition, any section 75. Also, that commission will be issued. So far as basic structure theory, I told you, I put a question. Basic structure theory that has been first evolved. That new concept was developed by the Honorable Supreme Court of India in Goloknath case. That while amending the Constitution as per Article 368, the basic structure of the Constitution cannot be amended. What is basic structure? Suppose there is a house. The house has some pillars. On that pillars, the house is standing. There are some basic structure on which the Constitution stands. If one of the structure is removed, that the Constitution will be demolished. So this is called basic structure. That structure, one of the basic structure which cannot be. Like in Minerva Mill case also, it has been decided that judicial review is the basic structure. That cannot be questioned. This question was amended. Yes, it is a basic structure. Basic structure, ଘରର ଗୋଟେ ଇଏକୁ କାଢିପାରିବ. This is, you should be aware of it. Apart from that, other interviews, many questions have been put. So other questions, you see this and prepare yourself. ଆଉ ଗୋଟେ very comprehensive हुआ, ମଝିରେ ମଝିରେ ବେଶୀ pause ନେଇକି କୁହ, ଆସ୍ତେ ଆସ୍ତେ. Don't be very quick in answer. Try to say in pause so that you will get less number of questions. More very speed, you are also answering very speedily. No. Try to develop this practice.
Okay, sir.
Okay, thank you.